Good afternoon, everyone. My name is Cliff Horn. I'm a public information officer here at TRSL, and we want to thank you for coming out today to our Return to Work webinar, where it's a legislative update to the Return to Work laws. As we get started, I just want to give you some technical information. As a friendly reminder that this presentation contains general information about the new updates when it comes to the Return to Work laws. The slides you see are meant to be used as a guide for the webinar. All of our participants will be muted, so you won't have to worry about any interruptions or odd sounds coming through. If you have a question, we will have a question and answer period towards the end of the workshop today, and you'll be able to type in your questions, and we'll go over that in just a few seconds. We also ask that you maximize your screen so we have you can see all the slides in their full and entirety. We worked really hard on making them, so we want to make sure you can see everything out of them. Right now, I want to go ahead and introduce our TRSL Executive Director, Ms. Catherine Whitney, and she's going to talk to you a little bit before we get started in the workshop.
Thanks, Cliff. Good afternoon, everyone, and thank you for watching today. We have a number of things to cover with you today. I think we have a little bit over 200 people attending the webinar, which is great because we want to ensure that everyone has the information they need as they attempt to implement these laws. But first, we'd like to share a short video message with you from our State Superintendent of Education, Dr. Cade Brumley.
Hey everyone, Dr. Cade Brumley, Louisiana State Superintendent of Education. As you can probably agree, there's nothing more important for the success of every student across our state than having a high quality teacher in every classroom for every kid. Some of those teachers could be retirees that worked in the system and decided to go into retirement. Well, now in the state of Louisiana, in critical shortage areas, there's an opportunity for those teachers to come back and serve. Legislation has been passed that allows those teachers to collect their retirement benefits, but also collect pay from their school system. We know that in the state of Louisiana, our kids deserve outstanding teachers. We also know there are many individuals who have retired from school systems in our state that might be willing to come back and give and add value to our schools once again. I encourage you to listen to these presentations that you'll hear today. You'll gain valuable information, and hopefully we can help do our part to provide every kid in the state of Louisiana with an outstanding teacher.
Dr. Brumley is absolutely right. We want all of our students to have outstanding teachers in the classroom. And I think that's why many of our legislators this past session focused on return to work bills that would be designed to assist in filling some of the critical shortages that you all are experiencing as districts. There were 8 return to work bills filed this session. 2 bills made it out of the process, both of which are designed to ensure that it would be made easier for you to reemploy certified retired teachers, while at the same time not having a significant impact on the retirement system. It's important to remember that some of these new provisions are temporary, so getting up to speed on them quickly will be key to being able to utilize them. So again, thank you for participating in this webinar. Please know that we have many valuable resources that are designed to help you in understanding the law and utilizing this law as this school year proceeds. So you will be hearing from shortly our return to work specialist, Jessica Trosclair, who is one of our most valuable resources in this area. But first, Cliff's going to go through how to ask questions during the webinar. Cliff?
Thank you, Catherine. So some of you probably have attended some of our workshops before, so this should be old hat for you by now, but just in case you are, if we have any audio issues, let me start with that. Any going in and out, losing audio, or just no sound at all, The easiest way to fix that is to go to the audio section in your tab and click on where it says computer audio, click on it to where it says no audio, and then back to computer. Effectively, what you're doing is you are disconnecting from our audio connection and then reconnecting, and it's basically effectively turning it off and on. As you go throughout today's workshop, if you have any questions, we'd ask that you look at the question bar that's available and type in your questions there. We here at the office will be able to see those questions and we will be able to answer them in our workshop today. As well as we are recording today's workshop, so you will receive at a later date an email that has a link to this video, as well as a copy of the handout or the PDF of the PowerPoint. You'll be able to get that as well, but you can also download it now in the handout section if you want to. Now, with that, we're going to go ahead and jump straight into our workshop today. I'd like to introduce our presenter for today, Miss Jessica Trosclair. She is our TRSL Return to Work Specialist.
Hello, everyone. Thank you, Cliff. So again, my name is Jessica Trosclair. I'm going to be walking us through the legislative changes and how they affected our return to work laws. This is not going to be a comprehensive training, but I do like to always start with an overview of the return to work laws. I find it helpful to see a big picture so that we can see how all of these pieces fit together. So we're just going to go ahead and start there. When we are talking about the return to work laws, we are specifically referencing Louisiana Revised Statute 11710. This is our 2010 return to work law. We have 11710.1, which is our 2020 return to work law. And new for this year is 710.2, which we will be referring to as our 2022 return to work law. That's one of the changes that we will cover. The other changes, for the most part, are going to occur within 11710. So within our 2010 law or our old law. So let's go ahead and take a brief sort of overview look at what changed, and then we'll kind of dive into the specifics. There was a change to the overall eligibility criteria for the 2010 versus 2020 group. So how individuals are placed into one of those laws. Within the 2010 group, we have two new provisions. So this is what Dr. Brumley was referencing in his earlier video. They will allow you to hire retirees without affecting the retiree's TRSL benefit. We also have a modernized change to the advertisement requirements for the critical shortage category, so an update to that process. And then, as we've briefly touched on already, there is a new law which is going to be a higher ed critical shortage piece. So again, we're going to start taking a deeper look. If you have questions at any point, please feel free to ask them. If I need to repeat something, I will try to do that, but if not, we'll try to cover everything at the end. Previous eligibility for the 2010 and 2020 return to work laws was based on a retiree's first date of reemployment. With the changes that came out of this legislative session, we're now only going to be looking at a retiree's date of retirement. So July 1, 2020 is still sort of the magic date, if you will. But now we're only looking at whether or not the retiree retired before July 1, 2020, or if their retirement occurred on or after July 1, 2020. Anyone before July 2020 will fall into the old return to work law. So they're going to be in our 2010 group. Anyone who retired July 1, 2020 or more recent, they will fall into the 2020 return to work group. Now, individuals have had the opportunity to convert from the 2010 law to the 2020 law, so they can move to the newer law if they find that it is more advantageous. That is still an option for them. We also have a new transfer option. This is a limited option. It is for specific individuals who have returned to work and under the prior eligibility criteria fell into the 2020 group, but they now meet the criteria for the 2010 group. So based on their date of retirement, even though they previously sort of defaulted or were automatically placed into 710.1, they are now eligible for 710. They will have the option to transfer into the 2010 group to take advantage of the categories within that law that allow them to return without affecting their benefit. So with that, let's go ahead and look at those categories. I'm going to start with the two new provisions to the 2010 group. This is two new ways that you can employ a retiree without affecting their benefit. You can employ them as a classroom teacher without adversely affecting their benefit. That means there's no suspension and there is no earnings limitation. Both categories are temporary, so they are only effective until July 1, 2027. They also only apply to direct employment. So if you have a scenario where you're employing a retiree via contract or corporate contract, maybe through a staffing agency, these categories are not applicable in those scenarios. And then we may all still be familiar, but the return to work laws do not apply to regular disability retirees. That remains true for these new categories. The specifics of these categories are as follows. So for our core subjects group, retirees who are certified to teach math, English language arts, science, or special education, not including gifted or talented, and who are hired in that specific area of certification can be reemployed to fill that position, again, without affecting their benefit. The second special group is the special leave category. So here, it's going to be when you hire a retiree to fill vacancies due to maternity leave, military leave, sabbatical, or extended sick leave per Title 17. Here, the individuals are eligible for this category if they are at least 62 years of age, have 30 years of service credit, and if they are certified. Now, there is one sort of caveat or asterisk on this core subjects provision, and it is that if a non-retiree, so an active member, applies for a position in an area where they're certified and where a retiree is currently employed, then by the start of your next grading period, and that's going to vary from district to district, but however your board or your parish has defined your grading period, the law will expect that you would hire the active member so that they replace the retiree. So again, just to repeat that, if you have a active member who is certified in math, English language arts, science, or special ed, and they apply for a position that is filled by a retiree, then the law would want you to replace the retiree with the active member. Now, if your agency chooses not to hire the active member for whatever reason, then just please note that the core subjects provision will no longer be applicable. We would expect a new enrollment type. We would expect that the applicable provision apply, and it would more than likely be retired member, which means the retiree's benefit could become suspended from that point on. And so one of the questions that I have been getting as I've kind of walked through these changes with different agencies is, well, how is an active member even going to know that I have a vacancy that's filled with a retiree? And that leads us into the changes to the critical shortage declaration process. So this was the second change that came about from this legislative session that affects our 2010 return to work group. Previously, if an agency wanted to hire someone and utilize the critical shortage category, they had to go through certain advertisement steps per position. And every time a new position came open, you had to repeat that process. The process has been sort of modernized, it's been kind of updated, in that now you're going to, rather than advertise per position every time a position comes up, you're going to be more so just posting a generic statement that says you are soliciting applications for future employment of certified teachers. This statement should be advertised at least once per month in your official journal, and it should also be posted at the Career Development Office of every higher ed institute within 120 miles, in-state or out. The third step is something many of you were probably already doing, but now it is directly tied to this critical shortage category. It is now a requirement. And it is that you must list all unfilled positions or positions filled with a retiree. You must prominently display them on the website of the employer or the employer's governing, of the employer or the governing authority's website. So if a separate web page is maintained, the list must be posted in both places. The way that I've tried to kind of simplify this and explain the change in this process is that rather than declaring a critical shortage per position, you are now sort of placing your parish into a critical shortage state. So it is a continual process, assuming that or showing that you have the intent of either using the critical shortage provision now or possibly in the future. These requirements do apply to full-time and part-time classroom teacher positions. In the past, part-time positions did not require advertisements, nor did the retiree have to be certified in the subject area. Going forward, full-time and part-time classroom teacher positions for the critical shortage category will be treated the same. So the requirements are the same. So we have a couple of questions coming in, but I want to get through just 2 more slides, just kind of a recovering what we've discussed. That's the gist of the changes that occurred with this past legislative session. And so what I want to take a moment to do is sort of compare or give you a brief overview of the 3 options that would allow you to employ a retiree without affecting their benefit, and of course without having any adverse effect on the retirement system, and to kind of show you which is the most efficient or how you can use them. So the first category is the critical shortage category. This is available to retirees certified in any subject where a shortage exists. It is a continuous declaration process now, but it is an annual certification requirement. So if your agency is continually in compliance with the advertisements and the posting at the higher ed institutes, then once you hire an individual into a critical shortage position, they can remain there for the remainder of the school year. When the next school year begins, you would start the hiring process all over again, confirm that you have the fewer than 3 candidate pool, and recertify any retirees that you may hire. We have the core subjects provision, which is available to retirees who are certified in math, English language arts, science, and special ed, not including gifted and talented. There is no certification process here. However, the position is not guaranteed. So what I mean by that is that this is the scenario when a retiree could be bumped for an active member. And then lastly, we have the special leave category. Again, this is available when you need to employ someone to fill a vacancy due to maternity leave, military leave, sabbatical, or extended sick leave. It is for individuals who have 30 years of service and are at least age 62. And just to reiterate, all three of these categories are specific to the 2010 Return to Work Law. So 710, they have to have retired prior to July 1, 2020, and they remain in the 2010 group, which means that if they make the election to move to 2020, these options will no longer be available. And so that brings me to my next point. There are pros and cons to converting from one group to another. Depending on how you are hiring a person, one law may be more advantageous than the other. Individuals who convert from 2010 to the 2020 group may do so because the earnings limit is often higher, or in many scenarios it is higher. Additionally, it is open to all positions. It's not limited the way the 2010 law is. The regain active membership option under the 2020 law allows a retiree to earn service credit while they have that suspension of benefits. So these are all reasons that many individuals choose to convert to the 2020 group. But as I've previously said, it is an irrevocable decision. So once an individual chooses to convert to be covered by 710.1, they will always be covered by 710.1. They will no longer have access to the critical shortage, core subjects, or special leave provisions. Now, for our special group who is able to transfer from 2020 into the 2010 group, these individuals are obviously going to find that transfer advantageous if they're doing so to utilize critical shortage, core, or the special leave categories. You may also have individuals who have an advanced speech degree and were automatically placed into the 2020 group, but now want to be able to take advantage of the advanced speech degree category under 2010, which lets them also receive their benefit with no impact. One thing to consider when transferring from 2020 to 2010 is that it is irrevocable again until July 1, 2027. So if an individual transfers to be in a category where their benefit is not affected, and then the hiring circumstances change, either you're no longer complying with the critical shortage process, or you do not have a need for a math or science teacher, then they're going to fall under the other provisions of 710, which means that they could have an earnings limit that would be lower than 2020, or they could be classified as a retired member and they would have a suspended benefit. And bear with me just a second. I see a question on this slide that I think I'm going to try to answer for you. So the question is, if someone has previously made the choice to convert from 2010 to 2020, are they excluded from the transfer to move? And so if I'm understanding your question correctly, if an individual starts in the 2010 group, so they start under 710, at some point in time, they made the choice to move to 2020, then that is irrevocable. So they will remain in 2020. They are not eligible to transfer back to 2010. That option is only allowed for individuals who were never afforded the opportunity to be covered by the provisions of 710. We have one more slide. We're done with the 2010 changes. We have one more slide, and then we'll kind of open up the rest of the questions. You guys are asking some great questions, and I really appreciate all of the feedback. So we're going to go ahead and get through this last slide, and then we'll open it up. So the last change that came out of this legislative session is the introduction of Louisiana Revised Statute 11710.2. This is our third return to work law. It is incredibly specific. It is a higher education critical shortage piece. So it allows for individuals who are adjunct professors in a nursing program where a shortage exists to return to work without affecting their benefit. There's no suspension. There is no earnings limit. There is a declaration process. It is not as extensive as the K through 12 process, but there are still a few steps that the hiring agency must take. And that is that you must list all unfilled positions as well as positions filled by retirees on the website of the Post-Secondary Institute, the institution's management board, and your Board of Regents. This requirement for both this higher ed critical shortage and also the K through 12 critical shortage, when you have to post your vacancies or positions filled by retirees, it's positions filled by retirees of any type. Okay, so again, for this critical shortage category, if you have a grandfathered person or someone in a core subjects position, and I'm sorry, that may not be applicable to higher ed, but your grandfathered retirees should be included in these vacancies. And then the last piece that we have for 710.2 is just who's eligible in terms of retirees. The individual would have had to have retired prior to July 1, 2020, so on or before June 30th. It, of course, does not apply to regular disability retirees. The individual has to have 30 years of service and be at least age 62. And one of the questions that I have gotten a handful of times that I want to go ahead and address is that once an individual is covered by 710.2, they are not necessarily stuck here, for lack of a better word. They can move back into 2010. They can have concurrent employment with a second agency. It's not an either or, it could be both in some scenarios. Okay, so that is the gist of the changes. I hope that this was simple enough to understand. If you all will give me just a second, I'm going to look through the questions that have been coming in. Some of them look similar, so I think I can knock a couple of them out with the same answer, but bear with me just a moment as I read through these. Okay, so we're going to start with a couple of the questions. Some of these are a little easier to answer than others. Some of the scenarios get very specific, and please understand that there may be scenarios that we ask you, or I ask you to email me the question if it is super specific to a certain scenario. The first is regarding the waiting period. So to clarify, the waiting period has not changed. There is still at least a 12-month waiting period within the 2010 law. So under 710, there is a 36-month waiting period. Now, anyone who holds an advanced speech degree or who is employed under the core subjects or special leave provisions, even if they meet the criteria for a 36-month waiting period, under those provisions, it will only be 12. There are no changes affecting the grandfathered group. So retirees who retired on or before June 30th, 2010 remain grandfathered. That category is housed within 710, and it again remains the same. One of the questions was, does speech pathology fall under the special ed group? And I'm not certain. Can you clarify that question for me? Whomever asked if speech pathology falls under special ed. I think I understand what you're asking, but I just want to clarify before we address that. There was also a question, does a retiree that returned to work earn service credit? So under 710.1, option 2 is the regain active membership option. Under that option, a retiree's benefit is suspended for the duration of reemployment and until they choose to re-retire. They are eligible to earn service credit under that option. They must be a full-time employee to be eligible for the option. Once they elect that option, all future full-time employment will be under that option. No other provision or no other category of the laws allows an individual to earn service credit. If unsheltered contributions are required, then for the other categories, they are simply refundable. And bear with me, I'm just looking through the rest of these to see if we can address all of them at the same time. Okay, so the question was, can we hire a retired speech pathologist under the special education core subjects? So if you are saying a retired speech pathologist who has an advanced speech degree, then they should just be enrolled under the advanced speech degree category. That category is very similar to grandfathered retirees in that as long as they hold that advanced speech degree, they can be employed in any position in any capacity. If you are asking about someone who does not hold an advanced speech degree and just a general speech pathologist who falls under special education, then let me look at that. Hold on just a second. Okay, so we have a question, and I'm going to read it, and then I will read the exact answer for you. When you're doing your advertising, the question says, is it just for teacher openings or also administration? Example, a principal. The advertising that is required for critical shortage positions, those positions are full or part-time classroom teachers, pre-K through 12, where a shortage exists. And there's also those 10 specialized positions. So speech therapists, speech pathologists, audiologists, educational diagnosticians, school counselors, etc. Those are the regular critical shortage positions. There were no changes to the positions that fall under critical shortage. I had another question that is referencing the 50% earnings limit. The earnings limit did not increase. There was proposed legislation that would have increased the earnings limit in the 2020 group, so under 710.1 to 50%. However, it did not pass. The earnings limits remain at 25% of a retiree's benefit in certain positions if the retiree is covered by the 2010 law. It is 25% of a retiree's final average compensation if they are directly employed and covered by the 2020 return to work law. So we had another question that says, if someone retired May of this year, so I'm assuming that means May of 2020, can they come back in a critical shortage for the 2022-23 school year, suspend their benefit, and then do critical shortage? So I think this, when you say suspend their retirement for a year, I'm assuming you're referencing the waiting period. Either way, someone who retired May of 2022 would fall into our 2020 return to work group. So they are covered by 710.1. Critical shortage is not an option for those retirees. For those under critical shortage, is it correct that they can stay in the position for the entire school year? That is correct. That still remains the same as it has been in the past. As long as you are continually advertising, so doing your monthly advertisements and posting at the higher ed institutes every semester. As long as you're in compliance, then once you enroll or hire that individual, it can remain for the entire school year. TRSL will auto terminate anyone who is employed in a critical shortage category on June 30th, and we would expect that certification process to begin again for the following school year. I'm going to read this question and then I'll answer it. It says, if you retired prior to July 1, 2020, you can elect to go to the 2010 provisions. Systems need to declare critical shortages as defined. Okay, and if after July 1, 2020, they cannot do critical shortage. So I think we're trying to make sure we have an overview of everything. So yes, if an individual retired before July 1, 2020, and they are defaulted into the 2010 group, meaning their previous reemployment history has placed them in 2010, they never made the election to convert to 2020, or this will be the first time they return to work, thus they fall under the 2010 group, they can be hired by any of the categories in 710, so any of the 2010 return to work provisions. If the individual is retired after July 1, on or after July 1, 2020, or if they have made the irrevocable election to convert to the 2020 law, they do not have access to the critical shortage category or any other provision under 710. They will always have an earnings limit based on their final average compensation, or they will have a suspended benefit with the potential to earn additional service credit. If you have a critical shortage now, or if at any point you think you may want to utilize the critical shortage, then it is in your best interest to start your advertisements and keep up with the process. It is a continuous process from here on out. That is not a temporary change. It does not sunset in 2027 with the other provisions. So you want to ensure if you're utilizing the critical shortage category, or if you have the intention in the future of using that category, you want to go ahead and keep up, start those ads and keep up with your monthly advertisements. The advertisements are the postings of the unfilled positions or positions filled with retirees. That is a requirement if you are a parish that uses the critical shortage category. You must include retirees who are employed in the core and special leave provisions. However, if you are an agency that does not use critical shortage at all, never have, never will, you don't intend to, then you can utilize the core subjects and special leave provisions. There is no declaration process. You do not have to advertise your vacancies in order to be eligible for the core subjects and special leave provisions. And I appreciate y'all's patience as we kind of read through all of these. The question one just came in, speech therapist positions can be rehired at any time, correct? And that is not necessarily correct as it's written. A speech therapist, if they hold an advanced speech degree, so that's speech therapy, audiology, or speech pathology. If they hold an advanced degree, they can be employed under the advanced speech category. And yes, they can be rehired if they're in the 2010 group. They can be rehired at any point in any position. If they are a speech therapist who does not have the advanced degree, then they could be hired, if they're in the 2010 group, they could be hired utilizing the critical shortage category if they are a full-time speech therapist. If they are an individual who retired July 1, 2020 or more recent, then unfortunately they are not able to return in any capacity without having an earnings limit or a suspended benefit. This question says, to make sure we understand, if you hire a retiree in a core subject position and someone else applies for that job, they must be hired to replace the retiree, and the retiree should be moved to another position. Generally, that is correct. If you have a retiree certified in one of those 4 subjects and an active member, a non-retiree, applies for that position, then the law would expect you to hire the active member. If you do not, if your agency chooses not to, then the core subjects provision is no longer applicable, and the retiree's employment would be reclassified under the return to work law. They would more than likely have a suspended benefit. You could absolutely move the retiree or employ the retiree in a different capacity if you have a need for it. It would require a new enrollment, but you are able to utilize the retiree in another capacity. So let's see, we have one more about critical shortage in core. Okay, so I did just go over this, but I'm going to say it one more time because I know this feels, the language is very similar, so I know it's kind of murky. If you have a retiree who, okay, let's first start this. Critical shortage is a category on its own, and core subjects is a category of its own. They are very similar. The differences are small and nuanced, but they are generally very similar. If you are an agency who is currently, so for the school year that just ended, you utilized retirees in a critical shortage capacity. So you went through your advertisement processes and you enrolled them under the critical shortage group. And then next school year, for the 2022-23 school year, you choose to enroll them because they're certified in math, utilizing the core subjects category instead of critical shortage. Then that retiree is only able to be reemployed and still receive their benefit if, basically, if no active member is applying for the job. When an active member, a non-retiree, applies, when they're certified in one of those core subjects and they apply for a position, a vacancy or a position filled with a retiree in one of those core subjects, then the retiree should be replaced with the active member. Again, the laws do not necessarily state who you can and cannot hire. If you choose not to hire the active member and you retain the retiree, the core subjects category is no longer applicable and their benefit could be suspended. So let me see if we have any other questions. Let's see if I think I've answered a lot of them with one answer. Bear with me just a second. I'm going to clean out this inbox a little. One of the questions that came in is in response to my answering the question about if they are in a core subjects position and then they get bumped by a active member or by a non-retiree. And so the question says, at that point, could they then be hired under critical shortage, or is it automatically a suspension of benefits? And the long story short is that if you have been continuously advertising, if you're compliant with the critical shortage declaration requirements, then you could terminate a person's employment under the core subjects law, and you could rehire them into a different provision. So you would have to show that you're meeting the requirements of whatever provision you may choose to place the retiree under, wherever you may have a need for it. So for example, if you're going to utilize critical shortage, you would have to refer to your applicant pool. You would have to say, at this point in time, what does our applicant pool look like? Who else do we have applying for these positions? Does it meet the definition of a critical shortage? Or are we going to hire the individual as a substitute classroom teacher, and we could use them under the earnings limit? So they do not have to automatically go into the retired member or the benefit suspension. That's if they remain employed with no change to their employment. A question came in that says, is the only change that applies to higher ed the nursing program critical shortage? And that is correct. The core subjects and special leave provisions are specific to K through 12, just by nature of the special leaves reference Title 17, and core subjects is for K through 12, math, science, English language arts, and special ed. And on that note, we've had a couple of questions about other subjects, whether or not or why they were not included in a core subjects, social studies, language, foreign language. There was another one about elementary teachers. And so core subjects is not defined in our return to work statutes. So you would refer to your DOE guidelines or bulletins in regards to how your certifications fall and which subjects are within those certifications. Okay, so I think we're wrapping up most of the questions. A lot of them deal with critical shortage and this core subjects category. And so what I do want to make note, one of the questions we've had is, when will the flowcharts be updated, and whether or not these questions will be posted online. These legislative changes are very new. They were just recently passed. So we are in the process of updating our enrollment program, and we are also updating all of our online resources. They will be available soon, hopefully within the coming weeks, so that you will have all of the resources possible to access this information and to determine where an individual falls and which categories are available. So we're just going to answer one or two more. Again, I think a lot of these are the same questions about critical shortage versus core. This question states, for the critical shortage positions, is it correct that they must remain advertised throughout the year? That is, yes, it is a continual process. It is, the law states that it must be posted at least once a month, and these are the permanent requirements from here on out. For the critical shortage category, the law does not state that you must hire an active member. What it does state, and this is not new, this is the way it has always been, is that you must have a candidate pool of fewer than 3 qualified applicants. So in regards to your candidate pool or when you can hire a retiree over an active member for the critical shortage process, it's going to be fewer than 3 qualified certified applicants. So with that, we're going to go ahead and kind of wrap up. I know we have had a ton of questions, and so my information is available on the slide. At any point in time, you are welcome to email me. We will post this webinar has been recorded, so you will receive a copy of it in an email in the coming days, as well as a copy of the handout. As we said, we're in the process of updating all of our online resources, so those will be available to you, including the return to work flowchart. And again, it is not a bother at all. You are welcome to email or call me at any time to get clarification on this information. I genuinely appreciate all of you being here with us today and taking the time to listen and to ask questions and to provide feedback. And I hope you have a great rest of the afternoon. Thank you.